this absolute nightmare scenario. You are fighting a criminal conviction, specifically a check bounce case under Section 138 of the Negotiable Instruments Act.
Right, which is pretty common.
Super common. So you do the right thing, you appeal the decision, you secure bail, and your jail sentence is suspended. And then, well, you wait.
You wait a really long time.
Exactly. For 8 agonizing years, your appeal just drags on. And during this time, you catch a really painful case of shingles.
Oh, wow.
Yeah, so you get a medical exemption for 1 court date. But at the very next hearing, you happen to run just a little bit late. By the time you actually walk through the courtroom doors, the judge has already canceled your bail and ordered you straight to jail.
Just like that.
Your freedom is gone simply because you were tardy.
All right, it sounds completely unbelievable, right? But that is the exact reality at the heart of the 2026 Supreme Court case, Meenakshi versus State of Haryana. For this deep dive, we have gathered the official Supreme Court judgment text, plus various legal commentaries, to look at this really stark, real-world problem.
Yeah, trial courts just mechanically punishing ordinary citizens over minor procedural hiccups.
Okay, let's unpack this, because the core legal battle here is deeply human. Let's look at how we get from a physical arrest to the specific piece of paper the state used to justify locking Meenakshi up.
Yeah, the state pointed to this standard bail bond document, which is Form 45 of the CrPC.
And just to clarify for everyone listening, the CrPC is the Code of Criminal Procedure, right?
Right, exactly. It's essentially the master rule book for how criminal cases are administered in India. And what's fascinating here is the state's incredibly rigid reliance on that specific form.
Oh, yeah.
Because the state of Haryana basically argued that, well, by signing Form 45, the accused legally mandates their own physical presence at every single hearing.
That is so wild to me. It sounds like the lower court was treating the bail bond like, I don't know, faulty software code.
That is a great way to put it.
Like if a single variable, say the time of arrival, didn't perfectly match the input, the program just automatically executed a send-to-jail command with 0 human discretion.
But, I mean, if I sign a bail bond, am I literally signing away my right to be human and run late? Why do lower court judges rely so heavily on a strict reading of these forms in the first place?
Well, that is the crux of it. Trial judges often stick to these really rigid, mechanical readings of forms like Form 45 because it actually protects them.
Protects them from what?
From being accused of leniency by higher courts or the administration. They basically treat it as a zero-tolerance contract just to play it safe. Break the bond by being 5 minutes late, and boom, the bail is automatically canceled.
But wait, I'm slightly confused here. Because if Meenakshi's appeal dragged on for 8 years, and the commentaries do note that she kept changing lawyers and causing delays, didn't the lower court judge have a valid reason to be frustrated?
Oh, absolutely.
I mean, how is a judge supposed to maintain order if the accused isn't held strictly to the bail bond?
And that is exactly the tension the Supreme Court had to resolve. The court acknowledged those delays, but they completely rejected the lower court's method of handling them. They applied what is called a purposive interpretation of the law.
Okay, so looking at the actual purpose of the rule.
Precisely. A judge must look at the purpose of the bail bond, which is to ensure the accused shows up to face the final judgment, not to micromanage their daily schedule for nearly a decade.
So you're saying the Supreme Court prioritized the constitutional value of personal liberty over procedural technicalities?
Emphatically. Yeah, they did not mince words at all, labeling the lower appellate court's actions as appalling and shocking.
Wow. Appalling and shocking.
Yeah, they ruled that forcing an appellant to sit in court for every routine months-long adjournment is an unwarranted burden. And to address your point about the delays and changing lawyers, the Supreme Court actually clarified the proper mechanism for that. Which, instead of issuing an automatic arrest warrant, the judge should appoint an amicus curiae, an assisting court lawyer, to step in and keep the process moving fairly.
That makes so much more sense. And because the Supreme Court framed this as a fundamental issue of constitutional liberty, rather than just a one-off scheduling mistake, this ruling is going to force a massive behavior change in district courts everywhere.
Absolutely. I mean, if you are a member of the general public navigating the system, the practical takeaway here is this. Getting bail during an appeal does not mean pausing your life to attend every single procedural court date.
Right.
However, you must always keep documented medical proof for unavoidable absences, just like the shingles diagnosis in this case.
Good advice. And, if you're a legal professional listening to this deep dive, Meenakshi versus State of Haryana is your new shield. You can use this directive to protect your clients whenever a lower judge attempts to weaponize Form 45 with a mechanical, non-bailable warrant.
Exactly. It really comes down to this deeply empowering note. The judicial process should serve justice. It should never function as a punishment itself.
Which brings us back to where we started. A woman stripped of her freedom over a minor delay, it really leaves you with a chilling thought to mull over.
Yeah, it really does.
If the Supreme Court of the country had to explicitly step in just to stop lower courts from jailing people for being late due to an illness, what other routine legal forms are currently being weaponized in the system right under our noses?